100 questions about a will challenge.
Good morning, Your Honor.
Mr. Donovan.
Good morning. We'd like to call our first witness, Dr. Kenneth Shulman. Good morning, Dr. Shulman. Thank you for your attendance today. Your Honor, with the court's permission, I would just like to keep things brief, and I propose leading this witness through some of his credentials.
That's fine.
Dr. Shulman, you're a medical doctor?
That's correct.
You obtained your medical degree from the University of Toronto in 1973?
It's that long ago, it's true.
You went on to do specialty training in geriatric psychiatry in London, England?
Correct.
And you completed a Master's of Science in Health Policy and Management at Harvard University.
That's correct.
You were formerly the psychiatrist-in-chief and head of the Brain Sciences program at Sunnybrook.
Also correct.
And I understand that you're the author of several papers on capacity and undue influence.
That's true. It depends on your definition of several, but it's true.
And you have been qualified before as an expert witness by the court in the fields of retroactive assessments of 1, capacity, and 2, undue influence.
And vulnerability to undue influence, that's correct.
You've been retained in this matter to provide a retroactive assessment of, first, the capacity, and 2, the vulnerability to influence of Mrs. Sophia Goldstein in the periods of June 2014, August 2014, and April 2015. Is that correct?
That's correct.
Your Honor, I would like to tender Dr. Kenneth Shulman as an expert witness in the fields of retrospective assessments of capacity and vulnerability to undue influence.
Any issue on that, counsel?
Oh, sorry, no objections.
I'm so satisfied.
Thank you. Dr. Shulman, have you prepared an expert's report in this matter?
Yes, I have.
I will ask that the witness be shown the package of materials for B'nai B'rith Canada seminar dated June 2nd, 2015 at tab 4. Following the acknowledgement of expert's duty, is this your report, sir?
That's correct.
May I ask you to very briefly summarize your clinical findings when it comes to Sophia Goldstein's capacity to make a gift in June of 2014?
Yeah, I'd be pleased to do so. Let me just begin by clarifying that my opinion here is entirely from a clinical perspective, and I certainly respect the difference between a judicial opinion, which is the purview of the court, and my role in these proceedings, which is to help the court understand the clinical context in which this issue is being reviewed, and any opinions that I offer would be from a clinical perspective primarily. So with that said, I'm happy to respond to your question. You're asking me about the gift that Sophia Goldstein made
in June of 2014.
June of 2014, when she gifted her home to her son.
Yes.
And certainly, from a clinician's perspective, this is a cause for concern because the gift occurred, a very significant gift, and a change in her previously apparently expressed wish to treat her children equally. The gift took place shortly after, almost immediately after, a time when she was in significant distress as a result of a subdural hematoma that she had just a couple of months prior, and that had been preceded by a period of time in which there was definite evidence of a decline in her cognition. So that, of course, raises concerns, and so that gift, from a clinical perspective, is of concern, and one would want to see documentation at the time of the gift, contemporaneous with that gift, as to her rationale, the consistency of her thinking when that gift was made in June of 2014.
So, Doctor, I don't want to interrupt you, but before we move on to the facts and the evidence that you may have considered, I wanted to zoom in on exactly what your opinion was with respect to her capacity to make a gift in June of 2014. Just briefly, can you tell us whether or not you arrived at an opinion on that?
Well, I think it's, from a clinical perspective, without documentation, I would say that from my perspective, the probability would be that she did not have capacity, unless one could demonstrate, as I said, that contemporaneously she could give a clear, consistent rationale that would explain the two basic aspects of any capacity. That is, the understanding of relevant facts. These are the essential components of all capacities, although, of course, capacities are task-specific. They differ depending on the task involved. But with respect to a gift, did she understand the relevant facts? Did she understand the value of the home that she was giving, what she was giving? And did she appreciate the nature of that, the effect of that gift? Did she appreciate the consequences of giving a gift? Those would be the things I'd be looking for. Failing that, in the context in which that gift occurred, I would be very concerned about her capacity to do so.
Thank you, Doctor. And may I ask you to summarize as well, very briefly, your opinion, if you formed one, as to the capacity of Mrs. Goldstein to make a will in August of 2014.
So the same issues apply in August of 2014. It's occurring at a time when she's compromised cognitively. She's been in hospital. She's had a subdural hematoma. There's evidence that she's confused, that she's no longer to function independently. And in the case of the will, even more so, this is a significant change from a prior expressed wish. We have a 2005 will in which she clearly opted to treat her children equally. Suddenly, in 2014, at a time of cognitive compromise, we see a dramatic change in that wish.
So before continuing on with any of the other facts that you may have considered, can I just ask you to be clear, if you formed an opinion with respect to that will in 2014, what was it?
You're pushing me on the opinion part. Again, that's why I started my testimony by saying that the ultimate opinion is the court's opinion. And what my opinion is clinically is only relevant insofar as it helps the court come to their conclusion. My opinion is that there would be very significant concerns about her capacity to execute a will at this time.
And as a matter of probability, if you were asked the question of whether or not she was likely to have had capacity at that time, what would your answer be?
Well, insofar as the probability of a clinical opinion matters in the court, then my opinion would be that she probably did not have capacity.
And may I also ask you the question, the following year, would you have an opinion as to her ability to make a will in 2015?
So one thing I learned from the lawyers is a certain new language. Doctors have their own language, but lawyers also seem to have their own idiosyncratic language. And my answer to that question would be a fortiori. She would not have had capacity in 2015.
I'm going to have to ask if somebody can tell me what that means.
The main a fortiori, well, I can help you. Even more so, even stronger, from forza, force.
Oh,
even stronger, because the evidence is that she's suffering from a progressive cognitive disorder, which only goes in one direction. And that said, from a clinical point of view, a subdural hematoma that caused an acute disturbance of mental state of cognition could be conceptualized as a delirium, in which case a patient or an individual can recover from a delirium to a certain extent. But in this case, with the previous history of a decline suggestive of a dementia, then the likelihood is that we're going to see continuing decline in her cognition over time.
Thank you, Doctor. And one additional question I'd ask you, just briefly, if you would summarize your findings or your opinion, if you formed one, as to Mrs. Goldstein's vulnerability to influence.
Well, I mean, clearly this lady was vulnerable. Anybody whose cognition is compromised and who has difficulty understanding and appreciating the issues that they are being asked to address would be vulnerable to influence if that influence was in fact exerted. So given the state of her cognition, given also, and again for the court to validate these facts, her complete dependency on her son Boris. Should Boris have in fact exercised influence on the decisions to gift the home, to change the will, to ban his sister from visiting his mother, then yes, I would say she was very vulnerable to having her will subverted if such influence was in fact exerted.
Thank you, Doctor. Now, you've spoken to us already a little bit about a subdural hematoma and about some other events that occurred in Mrs. Goldstein's medical history. Can I ask you just briefly, what information did you review in arriving at those facts?
So I did have the opportunity to review the medical records. We included her general practitioner's documentation. That occurred in 2012, in which he really felt that she was understanding what was going on in her life and had generally a positive attitude. He did note that there were some memory concerns. The difficulty with general practitioners' medical records or medical assessment is that they often do not probe into the cognitive state of their individual. That is, judgments about capacity and judgments about cognition are made on the basis of superficial banter often. And this is a very important point that we see repeatedly. Even people with significant levels of dementia can preserve their social graces. And unless you probe specifically their cognition, it's easy to miss the extent of that cognition. And this applies to the assessments that were done by the geriatricians, Dr. Slate, and even Dr. Rabinovich after the subdural hematoma. None of them, by the way, were asked to assess her testamentary capacity or the specific gift. So that's an important point to remember. But these records are always limited unless the specific question is probed and unless cognition is probed very specifically, which it wasn't really in any of the medical records that I reviewed.
When forming your opinion and gathering up these facts that you've been working with, did you have an opportunity to speak with any of the parties?
I met with Sophia Goldstein, and I met with her daughter Riva separately.
May I ask you first, when you met with Riva, were there any significant pieces of information that you gleaned from that meeting?
Well, again, Riva provided me with information to suggest that her mother's functioning had been compromised prior to the events in question, that there was evidence going back at least 2 years or 3 years of memory impairment, and most significantly, of impairment in ability to function independently. And that's a critical point in the history that might suggest dementia. Lots of people have memory impairment, lots of people have cognitive disorders, and many of us complain about memory. But when function is impaired, when the ability to function independently is impaired, then it becomes significant. Now, Riva's evidence obviously needs to be taken with some caution because she's in conflict in this case in terms of the actual dispute. But if her information is validated, then it certainly did suggest that her mother was beginning to show signs of dementia well prior to the subdural hematoma that took place in March of 2014.
So was the information that you received from Riva significant for your report?
The information I got from Riva was consistent with what I found in the medical records and with my overall clinical formulation.
Thank you, Doctor. And a moment ago you mentioned that you had also met with Mrs. Sophia Goldstein. What can you tell us about that meeting?
Well, that meeting simply confirmed the significant level of impairment that she suffered, her inability to understand the basic facts related to the issues at hand, namely that she had given her home to her son, the value of her assets, to understand the nature of the conflict between her son and daughter. And that's a very important point, too, in this case. People who are compromised have to be able to assess competing claims from in a conflictual family situation. And that, in my clinical opinion, raises the bar in terms of their capacity. They have to be able to appreciate the distinction between children who are fighting among themselves, making competing demands, making accusations against each other. And it was evident from my examination that Sophia Goldstein did not have a good understanding of that.
And if I could ask you to provide an opinion specifically with respect to her capacity when you met with her, capacity to make a will, what would you say?
From a clinical perspective, it was my opinion that she lacked the fundamental components of capacity, that is, understanding the relevant facts. In this case, the criteria of the traditional Banks and Goodfellow criteria, understanding the nature of a will, understanding the impact that the change in her will made. In fact, she didn't remember that she had changed her will.
Thank you, Doctor. I see that we're out of time, but I want to thank you again for attending today. My friend, Mr. Lobl, I believe will probably have some questions for you in cross-examination.
Doctor, you mentioned this Banks and Goodfellow. Is that an important case?
Apparently so. It's a remarkable.
How do you spell that?
I have to say that in medicine we're constantly trying to keep up with the latest information. We're implored to read up-to-date journals because facts change, knowledge changes, and yet the lawyers seem to be stuck on a case that was rendered in 1870 in the United Kingdom. But that's Banks and Goodfellow for you.
Thank you. Mr. Lobl, you're taller than the last time I saw you.
I ate my Wheaties. Good morning, Doctor. Doctor, you're aware that a capacity assessor has to give a rights advice to the patient before conducting an assessment?
Under the Substitute Decisions Act, that's correct. But I was not acting under the Ontario Substitute Decisions Act when I did this assessment.
Okay, and sir, you were aware that under the Substitute Decisions Act, you have to explain to, in this case, it would have been Sophia, that she could refuse the assessment?
Under the Substitute Decisions Act, that's correct.
And is there any other assessment protocol or act that would apply in this circumstance, sir?
No other act, but I was asked simply to give an expert opinion for the benefit of the court, not under a statutory act.
Okay, and you didn't ask Sophia whether she wanted to refuse the assessment that was being conducted by yourself?
I think in this case, as my report suggests, that I did in fact introduce myself and the purpose of the assessment, and it appears that Sophia assented to the assessment. There was no refusal, there was no resistance, and it became apparent to me early on that she wasn't in fact capable of an informed consent in this case, in any case.
So she was capable of consenting but not capable of making a will?
She was capable of assenting but not capable of making a will, that's correct.
Okay, sir, and you didn't obtain Sophia's consent required under the Personal Health Information Act to release her medical information?
This was done under a court order, not under the release of information. So I defer to the courts. When they order me to release information, that's what I do.
That's a good idea.
I was not provided with this court order.
I have a vague recollection that I received a court order.
I can't find the file, so don't worry about it. They lost it.
Sue me.
It's in the personal injury file, Your Honor. Okay, Doctor, you'll agree with me that having an understanding of the facts is one of the two fundamental components any mental capacity assessment requires?
That's correct.
And sir, you'll agree with me that in order for an assessor to have an understanding of those facts, the assessor needs to review all available information.
I would agree.
And that information would include the direct interview with the testatrix if alive, like Sophia in this case.
That's correct.
And it would include interviews with persons who had first-hand contact and experience with the testatrix.
That would be ideal, yes.
And people like spouses, if available.
Correct.
Children.
Correct.
Friends.
Correct.
Family.
Correct.
Colleagues.
Correct.
And that would include reviews of medical records of the testatrix.
That's correct.
And affidavits of witnesses filed.
That is correct.
Transcripts from witness examinations.
That is correct.
Other court documents like statements of claim.
Potentially, yes.
Statements of defenses.
Potentially, yes.
And you would review those documents so you could understand the allegations that are being raised in the context of a litigation, which you're being called to give expert evidence on.
Yeah, my response to that line of questioning is that yes, if necessary, one would want to expand one's review as broadly as possible in order to be sure of one's opinion. I would say from a clinical perspective, from my clinical perspective, that if one has sufficient information to come to a definitive opinion, it isn't necessary, and nor is it practical, to examine and interview every single person that the testatrix knew or would have information. And in this case, really fundamentally from my direct examination of the testatrix, and in the case, Riva, her daughter, was readily available, although I put less store in Riva's evidence for the reasons I cited earlier. My opinion was sufficiently firm that I didn't really feel the necessity to do the kind of exhaustive, time-consuming, and expensive review that you're suggesting might be in an ideal world.
Okay, sir, I'm going to hand you a document. Sir, have you seen this before?
Yeah, you've handed me a copy of a paper that was published in the American Journal of Psychiatry in 2007 by myself and co-authors.
And one of those co-authors...
Is it tab 5 of the material? I think it
No.
is.
Well, that's a good question. I don't believe it is in the materials before, Your Honor. I can hand you a copy of...
That's fine. I think I've got it. It's at tab 5.
Excellent. Whoever put that in the materials was very smart. And sir, this paper was co-authored by yourself and my opponent, Mr. Hull, as well, correct?
Yes, Mr. Hull was one of the co-authors of this paper.
And the title of this paper is Assessment of Testamentary Capacity and Vulnerability to Undue Influence.
That's correct.
Your Honor, how is this possibly relevant?
I have no idea, to be honest with you. I don't even know why I'm here. But that's okay. Go ahead.
Thank you, Your Honor. We appreciate that. And sir, if you can turn to, I think it's the third page of the paper, page 724, under the heading Role of the Expert Witness or Assessor.
Yes.
And about midway down that first paragraph, starting with the sentence, I think I highlighted it for you in your thing. The role of the expert may involve confirmation of capacity and cognition or mental state. And similarly, experts may be asked to assess a potential role of undue influence. After the death, the will may be challenged, and experts can be called upon to give a retrospective opinion regarding capacity or undue influence. And that's what you were called upon in this case. Is that correct?
That's correct.
Okay. And these assessments should always be made in the context of a careful review of the available information. That's what you wrote?
I did.
Yes, and they should include direct interview with the testator when alive.
Whenever possible.
Mm-hmm. And
in this case, that was possible, right?
That was possible.
I'm getting this now. Okay.
Mostly I deal with people who have died, but in this case it was unusual. We had a live testatrix.
And you also state that it should include interviews with persons who had first-hand contact and experience with the testator.
Yes.
Okay, so as you have penned in a medical journal, you would now agree with me, sir, that it is absolutely necessary for you to meet with and canvass the comments of all parties, including friends, family, spouses, and it's not a qualified situation as you put to me earlier?
Well, as is often the case in discussions of the Gemara, the small details are very important here, and each word carries significant meaning. And as you'll see here, I said these assessments should, I did say always, which was probably a mistake. You don't say should always.
I think that was Mr. Hull who probably wrote that, don't you think?
I think he inserted the always there. But I said should, not must necessarily. And we also said, I should say we, because I wasn't the only one who wrote this, interview with persons, and that doesn't necessarily mean every single person that the individual knew. It's obviously there's a judgment involved here in terms of who might be able to provide valuable information to help form the clinical opinion. And that could be one additional person, it might be two, it might be more. It's generally not necessary to interview the entire panoply of friends, relatives, and colleagues who knew the patient to form an opinion. So I would say, yes, in an ideal world, one should have all that information, including the medical records. And frankly, from a medical witness perspective, it's the medical records that are most important, because my role in these proceedings is to help the court understand the significance and meaning of what the medical records show, because I think that's the one area the court needs help with. The court doesn't really need help in having me, a medical person, give the court the opinion about which legal case, be it Banks and Goodfellow or otherwise, is most relevant. That is the purview of the court.
Actually, in this case, I do need your help.
Okay.
So I'll be
Clearly.
giving you a shout after,
All right.
okay?
All right.
Thanks.
Well, sir, but isn't it fair to say that, as you testified earlier, that interviews with friends or family will assist the assessor in confirming the information and formulating your opinion?
Yes, that's correct.
Okay, and in this case, sir, the only person, friend or family that you interviewed, other than Sophia herself, was Riva, the complainant in this matter.
That's correct.
You did not interview any of the friends or family, any other friends or family, correct?
That's correct.
But yet in your report, sir, at page 3, under the heading Corroborative Information from Riva Goldstein, midway down, you state that by 2013, friends and family began to notice difficulties in memory, concentration, etc. Yet that information you obtained solely from Riva and not from the friends and family, correct?
That's correct.
And so if friends and family were to come here today and testify and give contradictory evidence, that may change your opinion.
That's correct. If that was the case, then I'd have to review my opinion. And of course, that's the reason that a clinical opinion is only one component of the judicial opinion, because the court does have the ability to draw on a wider range of sources necessarily than an individual clinician might. So I take your point, and that is correct. Should other family members come forward or other witnesses that contradicted Riva's evidence, then yes, I would have to reconsider my opinion in that context.
Thank you, sir. And sir, in preparing this report, you have testified that you signed the acknowledgement of expert duty. That's correct. I think that's found at the end of your report.
That's certainly the standard of practice. I don't know if that happened in this case, but yes, I do sign in what's called a Form 53, Acknowledgement of Expert's Duty.
Yes, you did.
Yeah, I
Dr.
did.
Shulman.
Thank you. Thank you.
I'm going to hand you a copy.
Oh, yes, I did. Yes, thank you.
Sir, on page 2 of this document, that's your signature?
I guess it is. Yeah, actually, that's not my signature, but never mind. That's okay. That's a signature of my colleague with a similar name who does these things as well. It's okay. I stand by the acknowledgement.
Okay, so... Sir, in acknowledging your duty, one of the things that you've acknowledged, you would agree with me that you are to give an opinion that is fair, objective, and nonpartisan. That's 3A of the acknowledgement.
That's correct.
And you would agree with me that in order to provide an opinion that is nonpartisan, you would have to interview all sides of the case?
Well, I think that is not necessarily so. I think one can be nonpartisan without going to the extent of interviewing everybody on both sides of the case.
How about at least the main subject in the case, Mr. Boris Goldstein, who were all the allegations in the case are focused against?
Yeah. I think that would have been ideal in this case. I think my recollection, according to my experience, is that the witnesses on the other side of a case from which I've been retained are very reluctant to be interviewed by me directly. So that may have occurred in this case and explains why Boris wasn't interviewed. But I take your point. Ideally, I certainly would have wanted to hear Boris's side of the story, and then I would have still formed my own independent opinion.
Right. And so in order for you to have provided a report that was nonpartisan, you'd have had to interview my client in order to draw your conclusions as you did.
I wouldn't subscribe to that statement, frankly. I think I can still, and I would like to think that I am nonpartisan, no matter the limitations of my assessment. If I really felt that my clinical opinion depended on interviewing the other side, I think I would acknowledge that. But I wouldn't say because I only interviewed Riva and not Boris that my opinion becomes partisan. I certainly would hope, and it's certainly important for any medical expert, to ensure that they remain nonpartisan, no matter the limitations of the information that they used to form their opinion.
And nowhere in your report did you acknowledge that there were any limitations to your assessment, particularly in that you didn't get to assess or meet with any friends or family or Mr. Boris Goldstein himself.
Yeah, that's true. I think that's true. I think the reason for that is that from a clinical perspective, I was sufficiently confident about my concerns about her capacity that I didn't feel the absolute necessity to interview people from the other side. However, that said, as you've rightly pointed out, if the court does hear evidence that is to the contrary, then my opinion may need to be reviewed again.
So despite the fact that I'd like to examine you for another 4 hours on your terrible report, I'm told that I have to sit down. Thank you.
Thank you.
Thank you so much.
Dr. Shulman, just one question here. I'm looking at your report on page 2, and you talk about Dr. Slate's report. Mm-hmm. And Dr. Slate said, discussed Sophia's mental competency - okay in all caps with an exclamation point. I mean, shouldn't that be the end of this whole thing? I mean, you say okay in all caps?
Yes, I do.
You'd think that would be it.
Well, I'm quoting Dr. Slate, and as many of the lawyers in the room know full well, that unfortunately doctors do have their limitations when it comes to capacity assessment and understanding and appreciating the nature of capacity. And many physicians don't understand the fundamental principles that capacities are task-specific, they're situation-specific, and you can't draw conclusions about capacity by simply having a superficial social conversation with the patient who appears to be intact and say they appear to be fine and their competencies were okay in all respects. That unfortunately is a deficiency within my own profession, and many of my colleagues here and I are trying to do something to rectify that deficit in our medical education. Or in our medical legal education.
Thank you, Dr. Shulman. I'm ready to hear from the next witness.